This is a review of Module 10 um, that is focusing on a particular enumerated civil liberty, the freedom of expression. We're going to start out with just an overview and specifically look at what is protected by the First Amendment's freedom of speech clause. Obviously, words are protected. That goes without saying. We know words are speech and speech is protected. Um, a little bit of analysis is required when you're dealing with conduct, or some courts have referred to it as words plus, but just don't get confused by that. We're talking about expressive conduct when a person's activities are intended to express a belief. Okay, so in those situations, what happens? Well, expressive conduct is protected, and that was established in the U.S. Supreme Court decision of U.S. versus O'Brien. In that particular case, it involved a federal law called the Selective Service Act of 1965. This is at the very start of the Vietnam War, and it was a law that prohibited the burning of a draft card. During this time period, students in particular were protesting the U.S.'s involvement in the Vietnam War, and one of the ways they expressed their discontent with the government was to burn their draft card. And that is a means of expressing your discontent with the law. But in this particular case, the U.S. Supreme Court upheld it, and you've got to limit it to kind of the facts of that. Draft cards were the way that the government was able to keep track of who was eligible for the draft or who was eligible to serve in the war or not. So when you burn a draft card, you're destroying the government's ability to keep track of that. And so that may be the reason why in this particular case, the U.S. Supreme Court upheld a law that made a conduct that had been used as an expression of a political belief and allowed it to be considered criminal, but just limit it to the facts and the historical context. What really this case is really known for is establishing the tests that we use for freedom of speech. So in U.S. versus O'Brien, well, the court provided a test. I'll come back to these things. The test that a restriction must pass. Any sort of restriction on the freedom of expression is something the government has the burden to justify. So the government has to show an important or substantial interest that is unrelated to expression and provides no greater infringement on the expression than is absolutely necessary to accomplish its interest. That is what the O'Brien case did. That was its rationale and the reason why the draft card was upheld, or the ordinance against burning a draft card was upheld, was because the government had a substantial interest in tracking who was eligible to serve in the war. The law was written unrelated to whether cards would be used for political expression or not. That wasn't the reason why the law was passed. And it wasn't imposing any greater infringement than was absolutely necessary, than to no greater infringement than was necessary to uphold the government's ability to keep track of who was eligible for service. So it's limited to its facts, but O'Brien is really known for kind of starting the application of what ought to sound to you like strict scrutiny. And we'll come back to that in just a second. So expressive conduct is protected under the First Amendment. Texas versus Johnson, the holding of that case was that an individual could burn the flag as an expression of political protest. And it seems inconsistent with the O'Brien decision. In O'Brien, we're talking about burning a draft card. In Texas versus Johnson, we're talking about burning the flag. But in Texas versus Johnson, the court protected the right to burn the flag. And it was because the intent behind the burning of the flag was expressive conduct, and the court and the state of Texas did not do its job of establishing that its law was narrowly tailored. Political spending is also protected by the First Amendment. You may have studied this in other political science classes. This came from the two Supreme Court decisions, Buckley versus Vallejo and Citizens United. Both of those cases involved challenges to federal laws that restricted the right of individuals to spend money in support of a candidate for office. Spending money in support of a candidate is considered expressive conduct by our Supreme Court. So laws cannot infringe upon the ability to spend. And this is usually done in the form of advertisements. Donations to candidates absolutely can be restricted and are restricted by FEC regulations, but spending on advertising for or against candidates is protected speech. The First Amendment also protects the right not to speak. The right to, and don't put this in the criminal context. We're not talking about the right to remain silent, to avoid incriminating yourself. We're just talking about the right not to be forced to profess a belief. It's been seen applied to the right to not say the Pledge of Allegiance or not sing the Star-Spangled Banner, the right to refrain from expressing something you don't believe in. That is protected by the First Amendment. So now we're back to that test. O'Brien kind of gave us the start of the strict scrutiny test in the context of freedom of speech. And it still exists to this day. It still applies. It's worded a little differently. Now it's going to sound exactly like the strict scrutiny test. Government has the burden to establish a compelling government interest that is furthered by its law. The law must be narrowly tailored to cause the least possible interference with the freedom of expression. State action is required. The First Amendment, it was written to limit the power of the federal government, but the freedom of speech is a fundamental freedom, fundamental enough to be incorporated into the Due Process Clause of the 14th Amendment applied to states. When we're dealing with the freedom of expression, you have to be careful to notice the difference between content or viewpoint-based restrictions versus time, place, and manner restrictions. So it's the difference between laws that restrict what you say versus laws that restrict how you say something. So states, it's mostly municipalities, cities and counties, they can place some reasonable restrictions on how a person expresses their beliefs, particularly political beliefs. What they cannot do is make those regulations dependent upon what a person is saying, the content of what they're saying, the viewpoint they're expressing. So content or viewpoint-based restrictions are strictly scrutinized. Time, place, and manner restrictions receive rational basis review. Okay, so we talked about what is protected. Now we're going to talk about what is not protected by the First Amendment. What speech is not protected? And we start, obviously, from the graphic with obscenity. What is legally obscene is not protected, but it must meet the definition of legal obscenity. It can't just be something that offends you or that is indecent somehow. There is a specific case that came from the U.S. Supreme Court decision Miller versus California in 1973. That case, don't worry about the facts. Here's the test that it gave. An expression is legally obscene when the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest. You can look up the definition of prurient in the dictionary, but it must appeal to the prurient interest as a whole, when taken as a whole, after applying contemporary community standards. So that means there is no national standard for what is or is not obscene. It is a local determination. A jury decides, and it can change with the times. So we're talking about contemporary, what a contemporary jury finds to be appealing to the prurient interest. No national standard, and it can change through time. Second element of the Miller test: whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. What we're doing here with this part of the test is preventing states from writing statutes that are overly broad or vague, that would otherwise violate basic due process rights. The third aspect of the Miller test is whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So they are trying to provide protection for academic works, scholarship, artistic expression here. That's the Miller test, and that is provides us with the definition of what is legally obscene. It is a 50-year-old case, but it still applies. And as I mentioned, there is no national standard. It will change with the location and the time. So now we come to the controversial topic of child pornography. And I noticed in some of your discussion posts that this was bothersome, and I can totally relate to that. But let me try to explain what the law is. Whether you like it or not, this is what we're dealing with. First of all, the exploitation of children absolutely is a crime, and any depiction of actual exploitation of children is a crime and is not protected by the First Amendment. You don't even have to apply the Miller test. If you're depicting actual child pornography, real children, then it is a crime to do that. The First Amendment does not protect you. However, thanks to some of the downsides of technology, the internet technology has allowed for virtual child pornography, where no actual child is harmed or exploited in any way. It is absolutely abhorrent, but it is protected by the First Amendment. There have been a host of laws by Congress and by states attempting to make virtual child pornography, any sort of child pornography, a crime. But so far, the U.S. Supreme Court has struck down these laws because where there is no actual harm involved, what is being depicted is just an expression. The cases that are in your textbook, Reno versus ACLU, the Ashcroft case, and the Williams decisions, to understand this, you have to look at the specific law in each of those. And the analysis is focusing on the narrowly tailored aspect of the Miller test. So in the Reno case, I think it's the CDA, what is that? Communications Decency Act of 1966. It was poorly drafted. It was too broad. So it was struck down because it was making too much, drawing too much into its definition of criminal pornography. The Ashcroft decision, it extended its prohibition beyond just the actual exploitation of children to virtual images. So it wasn't limited to just what was legally obscene under the Miller test. It just wasn't narrowly tailored enough. But you get to the Williams case, United States versus Williams in 2008. Here, the statute was very narrow. It only prohibited the solicitation or conveyance of actual child exploitation. So that law was upheld. So where this legislation is very narrowly tailored to just actual exploitation, the First Amendment will not protect it, and the law is upheld. I hope that makes sense. Okay, so moving beyond the context of child pornography, we'll get into words that are intended to and do harm. Those such words are not protected by the First Amendment. Words that are intended to and do harm others. Example, defamation. These are words, if they are vocalized, it's called slander. If they're written, they're called libel. So that's the difference between slander and libel. They're both defamation, forms of defamation. Defamation, sorry. The harm done is damage to one's reputation. You can sue someone for defaming you and recover money damages. The First Amendment will not protect a defendant in a defamation lawsuit. You can recover if you show harm caused by the words to your reputation. Here's your caveat, though. When the words being said, the defamatory words, are criticisms of public figures or they are matters of public concern, they may receive some protection through an increased burden of proof, where a plaintiff has to show actual malice. So not just that the words are false, but that they were uttered with malice, with ill will. And that increased burden of proof is one way these specific types of defamatory defamatory comments can receive some protection by the First Amendment, because these expressions may be false, but they're about public figures or they're about matters of public concern. They are political expressions, so they ought to receive some protection. And the civil law provides that through this actual malice standard. But it is just limited to that context. When you aren't involving a public figure or a matter of public concern, the words that are defamatory, if they're false, you can recover in your lawsuit for them. Other words that that are intended to and do harm others, those are called fighting words. States can make it criminal to provoke violence through their breach of the peace type ordinances. Those laws are upheld. They just have to be narrowly drawn to just target the words that are harmful and intended to be harmful. Those laws must be viewpoint neutral. Another way of defining fighting words, it's kind of a different line of cases. Instead of calling them fighting words, they defined it as laws that incite and are intended to and are likely to incite imminent lawless action, provoking violence. The case that asked you to study on that issue was the Brandenburg versus Ohio case. That photograph that is in the PowerPoint there comes from that case. It was a group of KKK leaders holding a rally, but it was not really a rally. They were kind of deep in the woods, and the only people who showed up to the rally were the members of the KKK and a guy with a camera who worked for a TV station. So he recorded the nonsense and was going to air it on the news, but the police arrested the KKK group for what they said, and they challenged their conviction based on the First Amendment, and they won. And it was really because nobody showed up to the rally. They couldn't have been inciting violence because there was no one to incite. So that kind of gives you the context really matters for fighting words. When there is no one there and there's no chance of any sort of imminent riot, then the words are just mere expressions. They aren't dangerous at all. So they're protected. But then we get to hate speech. And that kind of has its own sort of analysis. And since it's a sensitive area, it's a controversial area, and I'll try to parse it out for you. You really have to look at the 4 cases that our textbook refers to. RAV versus City of St. Paul, Virginia versus Black, Snyder versus Phelps, and Wisconsin versus Mitchell. Look at the facts of the case and you'll start to recognize what the court's doing. Words are protected unless they are intended to intimidate an individual. Intimidation is a crime, it's an assault. So when your words are intended to do that, your words are criminal. Sometimes words are expressed and they are hate-filled words, but they aren't meant to intimidate. They're just meant to make a political expression. When they are just intended to be a political expression, however offensive they may be, they are protected. So in that sense, hate speech is protected. It's when the speech goes beyond just political expression and becomes a threat. That is a crime. That is not protected. So in the RAV case, RAV versus City of St. Paul, this was a cross-burning law, but it was written, it was based upon the viewpoint, the content of the expression. Cross-burning was made illegal when it was intended to be racially derogatory. So it was viewpoint-based, and the law was struck down because it was viewpoint-based. In Virginia versus Black, different cross-burning law upheld this time because it was not viewpoint or content-based, but rather it was part of a law that prohibited the conduct when it was intended to intimidate. Threats of harm, when you're trying to harm someone to threaten someone, your words are not protected. And then we have the Snyder versus Phelps case involving Westboro Baptist Church. It was a terrible situation where a church was protesting the funeral of a soldier who died in the line of duty who happened to be gay. This church is notorious for its opposition to homosexuality. The family of the deceased soldier filed a lawsuit against them, and they succeeded in defending the lawsuit. The church won because they weren't trying to intimidate, or at least the jury decided they weren't trying to intimidate the family, but simply expressing an abhorrent political belief. And I'm just reiterating here with this last bullet point, the difference between depictions of actual violence, they are not protected, but depictions of virtual violence where no one is really harmed, they are protected. That's the distinction. All right, also not protected. What is not protected? We're going to talk about student speech. Students don't have the exact same First Amendment rights that adults do. And this is because schools stand in loco parentis, Latin phrase, meaning that the school stands in the place of parents. They have the job of teaching children how to be decent human beings. And so they have the power to restrict some aspects of student expression. Restrictions are permitted where the expression violates school policy on indecency, bullying, or drug use. In the Brazier case, the school could punish, they are allowed, it was not a violation of the First Amendment to punish a student for giving a sexually explicit speech at a school assembly. In Morse versus Frederick, the school was allowed to punish a student for unrolling a banner that promoted drug use in front of a school event. However, in Mahanoy School District, this young cheerleader won her case against the school district based on the First Amendment because her expression did not violate school policy on indecency, bullying, and drug use. She was criticizing her teachers, her coach, and her school, but it wasn't interfering with school. It wasn't attributable to the school. It didn't violate any school policy. So the school could not kick her off the cheerleading team. They couldn't expel her or suspend her. Otherwise, they would have been violating her First Amendment rights. And in that case, the plaintiff, BL, that's her initials, the initials of a juvenile. They couldn't use her full name. Her lawyers tried to convince the U.S. Supreme Court to make a clear-cut distinction between on-campus versus off-campus speech, saying that off-campus students could say whatever they wanted. On campus, they could be restricted. The majority of the U.S. Supreme Court refused to make that distinction. So there is no fine line between on-campus versus off-campus speech. The analysis is whether speech that violates school policy on indecency, bullying, or drug use, whether or not it's on campus or off campus, if speech is attributable to the school, or if it materially or substantially interferes with the education process. So the Hazel versus Kohlmeyer case was a situation where the expression was a student newspaper, but it was part of a journalism class in which the teacher held editorial control over what the students wrote and whether it would be published. And because of that specific circumstance, the First Amendment rights of the students were not violated. The school could exercise editorial control over what was published in its own newspaper. The Tinker versus Des Moines case, that's the picture of the two students holding the armbands on the slide. That is where the rule about whether speech materially and substantially interferes with the education process, that rule came from Tinker versus Des Moines. But in that case, the students won because they were just wearing armbands. They were not interfering with the education process. They were just expressing their discontent with the Vietnam War. All right. What else is not protected? Commercial speech when it's false. Okay, so false advertising can be punished. That is not protected. False advertising. So otherwise, regulations are subject to strict scrutiny. So commercial speech is protected unless it is false and misleading. That's what you need to know. Okay, now we're moving out of the actual speech and we're talking about the First Amendment right to assemble and petition your government for redress. Petitioning the government is a right with a long history of protection, very little challenge to that right. It is inherent in a democratic society and it is upheld almost universally. This is only applicable to peaceable assemblies. Just when we are talking about the freedom of speech, and we say fighting words that are likely to incite imminent lawless action, they're not protected. So that means assembling in order to riot, not protected. Peaceable assemblies, marches, protests, those are protected. And the point you look for is, are those regulations, they're usually local ordinances on the right that regulate the ability of members of the community to march through the streets or to protest on public property. As long as they are viewpoint and content neutral, they're upheld. They just have to be reasonable. Those would be considered time, place, and manner restrictions, and they're perfectly fine. But if those types of regulations depend upon the content of the speech or the viewpoint of the speakers, the people protesting, they will receive strict scrutiny. Where they're neutral, time, place, and manner regulations, all they have to be is reasonably related to a legitimate government purpose. That's the rational basis test. All right, now we're going to talk last about the freedom of the press. And this is what your writing assignment, your essay was about. So I will touch a little bit on the essay at the end of this. But I've got to talk, I want to explain to you a little bit more about what the freedom of the press involves. To start out with, you have to recognize that newspapers, radio stations, television stations, cable service providers, and even social media, those are private businesses. And as we mentioned in the module, I think it was module 9 on due process, business organizations have due process rights the same way individuals do. So press and media are private enterprises, and they have rights to assert, including the freedom of speech. So the freedom of press is just an application of the freedom of speech to the media. The media, so there's two sides of that. They have due process rights just like individuals do. And just like individuals, they don't get special access. They don't have special rights. There is no First Amendment right to keep your sources confidential. You might see that on TV shows all the time where journalists refuse to disclose the identity of the informant or the person who's giving them information, their sources. They want to keep their sources confidential. Well, that's great, but you don't have a First Amendment right to do that. So you can be put in jail for not responding to a subpoena asking you for the identity of the source. State laws can give greater protection, but the First Amendment doesn't protect that. So the press has no greater access to trials. They have no greater rights to withhold information than an individual does. There are many government regulations of the media business, though, but they are given strict scrutiny when they are discriminatory. So if the regulations are content or viewpoint dependent, they're strictly scrutinized. They will be struck down if they are discriminatory on the basis of the content of what the media is saying or the viewpoint of the media. The reason why you might say that if there is any absolute right, there isn't, but if there is any absolute no exceptions, freedom or civil liberty, it might be the freedom of the press. It's not. There are exceptions, but it's about as close as we'll ever get to an absolute civil liberty. And that's because the role of the media historically has been to do the work of the people in checking the power of government. So whereas the average citizen may not have the wherewithal to investigate what government is doing and gather data, interview politicians, sit in on city council meetings, average people can't do that, but journalists can, and they're skilled in that way. So we rely on the news media to make government transparent for us, to inform us about what government is doing. And that makes the press a valuable tool in checking the power of government and holding government accountable to the people. And for that reason, any restrictions on the media are strictly scrutinized, especially if they are prior restraints. A prior restraint means stopping the presses. It's preventing the publication of information. So before the article gets published, before it gets posted on the internet, before it is advertised on TV or aired on the television, where the government attempts to stop it before it happens, that's considered a prior restraint. And to my knowledge, a prior restraint has never been upheld by the U.S. Supreme Court. The big case involving prior restraints is the New York Times case involving the Pentagon Papers. There's a movie about that called The Post. It's really good. And anyway, in that case, the Supreme Court refused to allow Richard Nixon to stop the New York Times and the Washington Post from publishing the Pentagon Papers. It was an absolutely illegal effort to try to hide the government's activity in Vietnam. So prior restraints are strictly scrutinized more than any other. But on the other side of it, when you talk about fining the government, fining the press, or somehow limiting their rights after the fact, that's sort of the flip of the coin on prior restraints. We're talking about after something is published, can the news media be punished for disclosing something? I don't see many cases involving that. We most often deal with prior restraints. There are aspects of media where they are considered platforms. So you might think of it in terms of publishing a subscriber's speech. These would be considered editorials. So like with a regular newspaper, like here in Greenwood, the Index Journal, members of the Greenwood community could write an article, submit it to the Index Journal, and ask the Index Journal to publish it in its editorial section. News media has often done that. For as long as there's been news media, individuals have been able to ask the newspaper to publish an editorial on their behalf and get it out to the public. So newspapers are effective tools for individuals to express themselves. So as well as having their own expressive conduct, their own words, the news media can be a medium through which other people express themselves. So it's kind of this twofold role. They have their own due process rights, but they also are a platform for individuals to express their freedom of speech, to speak their mind, state their beliefs. And there is an argument, you probably saw this in your writing assignment, there is an argument that where the news media acts as a host for individual expression, the news media can be prevented from silencing someone, from censoring what an individual wants to publish on their platform. That was the legal concept of being a host. You saw that, you would have seen that in the Fifth Circuit case. That was part of your writing assignment. But there is case law that protects the right of news media to exercise editorial discretion, to moderate what is being said on its platform. It has thus far only been applied in the context of a newspaper or a parade. There were a few cases in that you might have noticed when you were writing your essay. There is a right of editorial discretion held by newspapers. They can moderate the editorial sections of their paper. That is a right of the newspaper. What we don't know is the extent to which social media may hold that right of editorial discretion. Broadcast media, now we're talking about TV and radio. Now that is a unique situation because there are limited wavelengths on which TV and radio can be broadcast. So the FCC, the Federal Communications Commission, regulates it. And that is okay. They are content neutral. I believe they are all content neutral regulations, and they're just intended to make broadcast media fairly provide all sorts of information to the public. The right of the media, as I mentioned earlier, is coextensive with the right of individuals when it comes to access to criminal trials. So the publicity of a trial, the public nature of criminal trials, that is inherent in a democratic society to make criminal trials public. The news media has no greater right of access than any individual does, though. So keep that in mind. Judges have the ability to close trials, to limit pretrial publicity, to sequester the jury, And that is an effort to protect the Sixth Amendment rights of the accused. So judges are in this difficult place of having to uphold the transparency of the criminal process and yet also protect the constitutional rights of the defendant. Any effort to close a trial will be subject to strict scrutiny, but there can be a compelling reason to protect the Sixth Amendment right of the defendant that would justify closing a trial. The last little topic I wanted to go over with you is called the common carrier doctrine. And the reason this is not in your textbook, but it was part of the reading assignment for this module because it's part of your writing assignment, your essay. Both the 11th Circuit case, the Paxton case, and the 5th Circuit case, the Moody case, address the common carrier doctrine. And this doctrine, it doesn't only apply in the media context. It applies generally, and it is a basis on which governments can heavily regulate a business activity. The activity of a private business can be regulated under this doctrine when that business provides a service to the public that the public can get nowhere else. So it's kind of like a situation where a business holds a monopoly. If the only way you, for example, like in a case where there's a river that members of the community must be able to cross to get somewhere, and the only ferry service that exists is provided by this one business, the government can make that ferrying business provide carriage to everyone, to not be able to refuse service to anyone, because that's the only way people could get across the river. It's like they had a monopoly and the government's regulating monopoly. That's the common carrier doctrine. The argument is being made that social media is a common carrier, or is more akin to a common carrier than they are to a newspaper. So if the U.S. Supreme Court sees them like common carriers, like these large social media platforms are the only way that individuals might express their political beliefs, okay, if that's what the court finds, then Texas and Florida can impose these regulations that limit the ability of social media to deplatform certain political expressions. But if the court decides no, social media is more like a newspaper, then it will have the right of editorial discretion, and Texas and Florida cannot prevent them from moderating their content. So that's how the common carrier doctrine works. And I wanted to go over that with you to try to help you understand what you were doing with your writing assignment. I haven't read your essays yet, but I'm going to assume that you all already have that in hand and wrote fabulous essays addressing the issue. That's all for this module on the freedom of expression.